person acting under color of law. Other civil and criminal law.
Okay, so apparently that was the House of Representatives. My bad. This is the Senate, and so far they have not gotten to our bill. I double checked,
SB 2217
and
people in the whole
it is
chain of command subject
in the same bill
potentially to
for
complaints
the
and,
entire time.
lawsuits
So,
and litigation and settlements. So I think the senator, again, like the previous amendment,
we have
is
not missed
bringing
anything,
something that
thank
improves
goodness.
the bill and just narrows it more clearly to where we want to focus on potential abuses. So I support the amendment.
Further discussion on the amendment? Seeing none, the motion before us is the adoption of Amendment L006. All those in favor say aye. Those opposed, no. The noes have it, and that amendment is lost. Senator Kirkmeyer.
Hopefully our bill won't be too long.
Members, heard that there's a question as to why we aren't championing this bill, because it's to protect from federal overreach. No, the way I read the bill is it's to be able to allow one individual
Considering
to sue
they've
another
been
individual.
on this one
I mean, right here in the summary of the legislation. The bill allows individuals who have had their constitutional rights violated
bill for
would have to be proven
approximately
during a civil immigration enforcement action
over
sue
an hour.
An individual participating in the enforcement event, whether or not.
Well, that is pretty heated, so.
This bill doesn't say that it's only whether they're acting under the color of law. It says whether or not they are. Oh, there was a committee amendment. Thank you. No wonder that changed in the fiscal now.
Yeah.
All right. Well, that's good to know. All right. So.
I guess they're trying to get ahead of Minneapolis.
Person who is injured during a civil immigration enforcement by another person who, whether or not they're acting under the color of law, right? Is that what it says? Struck whether or not by another person who is acting under the color of law. So that could be a law enforcement official. That could be a firefighter. That could be a Division of Wildlife individual who may be acting under the color of law. That could be pretty much any first responder. But that's what this bill is about. It's about allowing individuals to sue another individual. That's what this whole bill is about. And the part about the maximum extent permissible under the United States Constitution. A grant of immunity, and there's a whole list of immunities here, does not apply in an action brought pursuant to this section. This happened before in a different law. It happened back in 2019, Senate Bill 217. Governmental immunity, Colorado governmental immunity, changed. And so what happened, at least at local government, is that it got really very difficult to hire law enforcement officials. It got extremely difficult to hire individuals in our correctional facilities at the county level. We already know we have individuals, it's very extreme. We have a workforce shortage. It's hard to hire people in the state's correctional facilities. So a law enforcement officer, and this is what they said to us as a Board of County Commissioners, if our immunity's gone, why should we walk out the door and protect anybody every day when we could lose our house for just merely doing our job? That's the concern that's brought up. We all know where this bill's going. Head it to court. First case, it'll go to court. And the other thing I want to point out to you is in the next section on page 5, or in this, 4, section 4, or paragraph 4, and as used in this section, unless the context otherwise requires, civil immigration enforcement means an action to investigate, question, detain, transfer, or arrest a person for the purpose of enforcing federal civil immigration law. Does not include an action committed by a peace officer who is acting within the scope of their peace officer's duties consistent with state law. I don't know how that relates to and goes back to all the laws that have been passed that have turned us into a sanctuary state. I don't recall the number on the bill last year or what portion of statute it's in, but the law last year that's pretty much said any individual, any state employee, any bus driver, the individual from the Department of Labor who didn't want to turn over documents that the governor thought he should turn over to the feds. We put in state law that if you do anything to work, essentially, this is how I'm paraphrasing it. I'm sure there'll be a attorney who comes down here and talks about maybe how it's different, but this is how it was interpreted, at least by everyone else, that you can't work with the feds or you get penalized up to $50,000. Remember the deputy in Mesa County got challenged? Could have cost him $50,000 a day. Wasn't it a day? There was a penalty, even if it's just $50,000 period. I don't know how much you think law enforcement officials make, but it's not that much. So, to the maximum step permissible under law, a grant of Colorado governmental immunity does not apply in an action brought pursuant to this section. What that means to your everyday worker, everyday law enforcement individual, everyday anybody is, look, you're not going to get Colorado governmental immunity. It'll be on you. You will not be covered under the immunity. That's what that means to the folks who are on the ground who do this, to the first responders, any first responder, essentially. And as used in this section, civil immigration enforcement does not include an action committed by a peace officer who is acting within the scope of the peace officer's duty consistent with state law. Clever language. As long as they're consistent with state law. Well, remember, we have a state law that says if you work with the federal government, you can get penalized. You get a penalty. These two sections, these from line 1 through line 615, most first responders, law enforcement, people who are covered under the Governmental Immunity Act and these other intergovernmental immunities, qualified immunity, feel like their immunity will be in jeopardy. And they could lose everything. After Senate Bill 19217 passed, it was difficult to hire people. What has occurred since then, and with all of the other laws that have been passed? Law enforcement walks away. We've become the second most dangerous state in the nation. And then there's also this other obligation. First responders have an obligation and a duty under federal law. They have things that they have to comply with under federal law as well. And then I'm just going to direct you to the fiscal note. So the fiscal note says that it's $125,000, half an FTE. Those are the state fiscal impacts. That the costs are assumed to be paid from the risk management fund. The risk management fund comes from affected agencies, which is a mix of general fund, cash funds, and federal funds. So it's going to be determinant upon which agency is going to have to pay into the risk management fund to pay for the approximate $3.3 million per year beginning in 26-27 that the Department of Personnel and Administration estimates that the risk management expenditures will increase by. Now, typically, the risk management fund gets general fund, it gets cash funds, and federal funds. Usually, it's about 60%. When we're doing reappropriate funds, moving things around and doing all this and getting it from the state agencies, at least 60% is usually from the general fund. So we can count on that 3.3 million, it's probably going to be about 2 million in general fund. What's missing in the fiscal note is the cost to the locals. So first of all, the cost to locals is going to be, it's going to be more difficult for them to hire anyone to provide for the safety in our neighborhoods, to provide for the safety in our county jails. It's going to be more difficult for them. But there's nothing in here about how much it costs or how much these pending lawsuits will cost local governments. Nothing. There's nothing in here, and under the color of law, I mean, we have a lot of first responders who have duties and responsibilities under the law. That one, we're jeopardized, first of all, because we're a sanctuary state and because of the law passed last year. And then because we keep putting things into law about Colorado Governmental Immunity Act, making it more difficult for us to get any first responder. Any first responder.
There is an amendment at the desk. Clerk, please read L007.
Amendment L007, amend printed bill, page 5
Senator
after line.
Kirkmeyer.
Thank you, Mr. Chair. I move L007.
To the amendment.
Thank you, Mr. Chair. This amendment only applies during times when a statewide disaster emergency is declared by the governor, or an emergency or a major disaster in the state is declared by the President of the United States. So a presidential declaration in our state is declared. And what it says is, notwithstanding any provision of this section, which is on page 5, after line 18, notwithstanding any provision of this section to the contrary, a person does not have standing to bring a civil action pursuant to this section for an injury as a result of a conduct that occurred during a statewide disaster emergency declared by the governor. And typically, folks, just so you know, when a statewide disaster emergency is declared by the governor, that is when the president will declare a disaster in our state. This is just in our state. Disaster in this state declared by the President of the United States. If he doesn't declare a statewide disaster or a state disaster, meaning the President of the United States, we don't get a presidential declaration, it doesn't open up any federal funds or limited federal funds. So it would only occur during a statewide disaster emergency that not only law enforcement, but first responders will not have to hold back. So if we're in a situation where we're having an emergency disaster and a first responder, an emergency medical technician, EMS guy, firefighter, law enforcement officer, a health care first responder acting in their responsibility to respond to the disaster, if they don't know if they are detaining or questioning. They don't know who they're detaining or questioning. They're not asking them. They're not asking them, could this be a civil immigration enforcement? They're not saying that. But if somebody is looting from a store, law enforcement officer, local law enforcement officer, detains them and starts questioning them, it could be a problem. It could be a problem. So all I'm asking for is that during a disaster emergency, that notwithstanding any provision of this section, a person does not have standing to bring a civil action pursuant to this section for injury as a result of the conduct occurred during a statewide disaster. Folks, things happen in a disaster emergency. When you're trying to assist people, when you are trying to assist them, maybe to remove them from the fire area, and they resist. There are a lot of people, when you tell them to evacuate, that an emergency evacuation order is in place, they don't leave. I mean, I can think of flooding situations,
don't let
fire
'em.
situations, where people are like, no, you know, if the house is gonna go,
Yeah.
I'm gonna go with it. I'm of that age, I'm not moving. People won't leave in an evacuation. So if a first responder forcefully removes someone from their home and they don't know that there could be a civil immigration, that the law could be that, you know, they're detaining and they're detaining or questioning someone that could be involved in a civil immigration enforcement
No one
issue.
should be forcibly removed from their home
Do they really have to have this situation
Without
occur? Do they really have to have
proper
where their
documentation and
governmental immunity, their
warrant.
immunity is stripped from them? I mean, we tried the knowingly and intentionally part, that didn't work. So in an emergency disaster, when it's been declared by the governor or by the president in our state, this section would not apply to those first responders. I ask for an aye vote on Amendment L007.
Senator Weissman.
Thank you, Mr. Chair. Going to ask for a no vote. I think even after that discussion, it's a touch unclear the full extent of a disaster declaration intended. This one famous example we talked about years ago in a committee where there had been a problem with the wheat harvest, or perhaps it was the corn harvest, and believe it or not, a disaster was declared by way of unlocking or hoping to unlock, federal funds. Obviously, COVID was quite a long disaster. So these things have a way of going on for a while under conditions that we wouldn't necessarily inherently think of. At any rate, I don't think constitutional rights take a break. I think actually the experience of our country at the founding and the conditions that gave rise to the Bill of Rights that, again, have been enforced in state courts for a long time, whose antecedents were enforced in the courts of England before we were a country. I can cite you cases from the 1750s. It's exactly under disaster or emergent conditions that sometimes, under the wrong kind of authority, civil rights and civil liberties are most likely to be trampled. It is under such conditions when we need to be most attentive to protecting constitutional rights, including by way of remedies. There was talk up here of lawsuits and lawyers. Yeah, this is a bill to let people, if their rights are violated, file a lawsuit, because that's how you enforce your rights in this country. DC v. Heller was a lawsuit. McDonald v. City of Chicago was a lawsuit. The end of Roe was a lawsuit. And if somebody shot 10
If you're
times
gonna wear a bow tie, at least wear it right.
after
He looks like
investigation, I
he's
think they
just
had at least
finished
6
drinking
minutes
at a
to file a
rodeo.
lawsuit too. Frankly, even if there had been a disaster declared. I ask for a no vote.
Further discussion on this amendment, Senator Kirkmeyer.
Thank you, Mr. Chair.
She just
People
left.
generally have the ability to file civil action pretty much at any point. They've got a lot of opportunity to file civil action if they think they have been treated wrongly and treated inappropriately. People have those abilities. It's the consequences and the unintended consequences of this law that I'm concerned about. after we've passed several bills down here, well, not we, after bills have been been passed down here, of course, first responders, and they just move somewhere else, like out of state, because they don't feel valued. After some of the laws that have been passed, law enforcement just stands back. They don't do anything because they're afraid to act. After that Mesa County deputy, the Attorney General went after him, and he thought he could pay a fine of $50,000. It sent shockwaves through the law enforcement community. The last thing we want is for a first responder, if there's a huge fire that's occurring in Aurora, and it's taking over buildings, and it's causing a problem, or in El Paso County, because it actually happened when I'll just use El Paso County as an example. When they were having those fires a few years ago, it looked like all of Colorado Springs was burning. Last thing we want is for a law enforcement, first responder, a firefighter, an emergency technician, is to hold back because they're afraid of being sued. And they're afraid that they've already lost their governmental immunity, and they're afraid they lose their home and everything that they have fought for with their own family. That's what this is about. The emergency disasters don't go on forever. The governor has to set a date for those. In a presidential declaration, there are specific dates set within the declaration determining the time of the disaster and the duration of the disaster for which the federal government would pay any money out during that disaster. The same thing
These two
happens
should
within
just
the
fist
state.
fight and get it over with.
Yeah.
So again,
Where's the battle
it's the
arena?
unintended consequences.
Yeah.
First responders holding back in a disaster, in an emergency, not a good idea. There are unintended consequences to the legislation we pass. We all know it. But do we really want them holding back? It's already bad enough we're the second most dangerous state in the nation. We talk about protection from federal overreach. I would just like protection in my neighborhood. Just like to have protection in my community and my county. I'd like law enforcement, I'd like firefighters and emergency responders, any first responder to know that I've got their back because they have our back. That's what this amendment is about. I ask for an aye vote on L007.
Further discussion on the amendment? Seeing none, a division has been requested. Division has been requested. All those in the chamber not entitled to vote, please be seated. The motion is the adoption of Amendment L007. All those in favor, please stand and remain standing without moving around the chamber until the count is complete. Please be seated. All those opposed, please stand and remain standing. The chair is not in doubt. Amendment L007 is lost. Any further discussion on the bill? Senator Baisley.
Thank you, Mr. Chairman. So the essence of Senate Bill 005 is this sentence: a person found to have violated the United States Constitution while participating in civil immigration enforcement is liable to the injured person for legal or equitable relief or any other appropriate relief. I want to bring attention to this Constitution that is referred to in this bill, the United States Constitution, specifically Article 4, Paragraph 4, which reads, "The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence." So
Yeah, they're
I want
talking
to
about towards like army or
that
terrorist
agitator is
organization
interrupting
or something like that.
the authority and responsibility of the United States government in its action, guaranteeing us against invasion and against domestic violence if someone injures an officer who is enacting that provision and injures that officer, then that person would be subject to the liability described in this bill. Thank you, Mr. Chairman.
Senator Frizzell.
Thank you, Mr. Chairman. In speaking about Senate Bill 5, I just kind of want to go on record about my thoughts on this bill and echo some of the sentiments you've already heard today. First of all, this bill is extremely broad in application. It is not just, and we've tried to run some amendments that I believe were very well thought out and common sense, but narrowing this to federal immigration officials makes perfect sense to me. And the reason why it makes perfect sense is that my good colleague from Brighton is correct. Local governments are the ones who are going to be bearing the financial burden for this bill. Local government. And the costs of those issues that when they arise are going to be passed directly onto those citizens in that locale. I also want to talk a little bit about the role of local control in this matter, because what this bill does, because of the financial burden being passed to local government, is that it really will work to prohibit local law enforcement from participating in civil immigration enforcement. It just will. I know that in the communities that I serve, that I represent, the Douglas County
I don't
Sheriff's
get it.
Office
Did they not
takes
just vote
their role
on
in
passing it or not?
immigration enforcement very seriously.
No, that was another bill.
And
I
they
don't know.
view
I'm
the
confused.
government
It was
not an
L007 they just voted on, but they had SB 26005 up on the screen.
And I appreciate that mindset. I really do. I appreciate that mindset because it's healthy. It keeps our communities safe. Now, yeah, there's going to be occasional bad actors. There are in any industry or profession. There are going to be bad actors.
What is she
We
talking
already
about?
have laws on the books that deal with that. But this mindset
Actors?
of
I don't
painting
know.
all law enforcement
No,
as
like
bad
she's talking about like industry
is
now, and like
detrimental to our communities. It's detrimental to this profession that, you know what, we rely on. Colorado has a crime problem. The second most dangerous state in the
as has
country.
been presented.
Is that the Colorado we want? Is that the
Apparently, y'all
Colorado
made
that
it that way.
our citizens deserve?
Yeah.
I think it's our responsibility in this chamber to support first responders, not denigrate them. Support them for the good work that they do. That is not what this bill is about.
Y'all apparently have much more deep-seated problems that y'all aren't touching on. If y'all are the second most dangerous state in the nation,
Yeah.
I ask you for a no vote on this bill, on Senate Bill 5. This bill is not good for our communities because it takes away local control. It is not good for the citizens that we represent because it will make this state less safe. If we don't have people who are willing to raise their hand and take an oath to protect and serve our communities, if we don't have those people, then we'll become even more lawless than we already are. Thank you.
Senator Zamora Wilson.
Thank you, Mr. Chair. So, someone who served in the military, I support strong national sovereignty, border security, and this bill raises concerns. As far as it will deter federal immigration enforcement, and it's going to create new civil liability in Colorado courts. Immigration laws are to uphold the rule of law and protect national security. Also to preserve the integrity of the legal immigration process. And those
this is
are
like an insane roller coaster ride. I feel like they just voted on this bill, but it's not this bill.
Yeah.
On our enforcement.
Like, is
like
this
they're talking
politics
about
now?
the same thing, but they're not.
This is going to cause recruitment to go down because now they are incurring.
Are they talking about divisions inside of
And as
the
my colleagues already mentioned,
same law?
second most dangerous state, Colorado.
I guess.
And we're going to create a situation which is going to cause a decrease in recruitment of our law enforcement. Is that really what we want? As mentioned, if such individuals are considered protected by the Constitution, I mean, that's what we have the Constitution for. They are protected. This bill has broad language. When we look at, especially the cost, it's, my goodness.
Y'all are the second most dangerous state in the nation, and y'all are cracking down on gun barrels. I think you'll have bigger problems than gun
As I
barrels.
mentioned, the fog of war
Yeah.
in these contentious situations.
I think y'all have your priorities just wrong. But I can't
in
say that for certain because I don't live in Colorado.
litigation costs.
But thanks to this and all the stuff I've learned, I don't want to live in Colorado.
There's going to be some unknowns, and obviously in the complexity of the cases and case outcomes. And it states that we're going to see total costs of over $125,000 per year. We're going to see settlement costs, and they can range tens of thousands to millions of dollars. An increase in the judicial workload. And as was stated before, who's going to pay for this? The majority are local government. State and local governments will have increased costs for litigation, settlements, and risk management. And as my colleague from Brighton pointed out, 60%, when we're talking about in the risk management, $3.3 million for the years 26 through 27. 60% is going to come out of the general fund, about $2 million. Is this really what we want? Putting the burden on our local governments, decreasing our law enforcement when we're already ranked number 2. It's an overreach that threatens our effectiveness on national security. It prioritizes potential claims of non-citizens or citizens. What safeguards exist to prevent frivolous or politically motivated lawsuits? We've tried to put in some guardrails. I don't see any. And so, again, you're going to see an increase in the demand of these lawsuits. It's going to be a burden on our judicial system, our local system. It's going to be a huge cost to the taxpayers. And I will state it again, if protecting constitutional rights is the goal, then why don't we support reforms that are at the federal level, rather than creating a state level workaround that invites preemptive challenges. I urge a no vote on SB 26005. Thank you.
Senator Rich.
Thank you, Mr. Chairman. And just to piggyback on something that was just said, you know, there's already 50 counties that have voiced their upset about the unfunded mandates. And this is clearly one of those unfunded mandates that I haven't seen anyone or any of the sponsors concerned about it this time. But this bill threatens lawful immigration enforcement practices with vague language that could impose onerous legal punishments on law enforcement and ICE agents who are lawfully performing their duties. This bill will virtually allow anyone, including non-citizens, to frivolously file suit against law enforcement agents, thus needlessly impeding immigration enforcement activities that aim to protect communities. I think I did hear one of the sponsors say, yes, there'll be lawsuits. Well, that just furthers, you know, that profession to file lawsuits. This bill poses a significant obstacle to federal immigration officials and their local law enforcement partners, undermining their ability to enforce immigration laws effectively and efficiently to ensure community safety. The bill enables individuals to obstruct immigration enforcement by encouraging lawsuits and legal challenges, often frivolous. The bill fosters an environment of retaliation against immigration personnel, escalates tension, and increases the risk of conflict and violence during immigration enforcement efforts. This bill continues to solidify what I believe Colorado has become, a pro-criminal state. I ask for a no vote.
Minority Leader Simpson.
Thank you, Mr. Chair. Colleagues, I find myself thinking about a comment from the good senator from Denver in this kind of really weird, odd policy conversation. Certainly want to advocate and stand up for protecting people's constitutional rights. That's inherent in all of us, I think. So challenge is like, how do we have this policy conversation with that end game in mind of truly protecting people's constitutional rights? I think about as the bill was introduced, and recognize it was amended in committee, but as introduced, it certainly felt like, I just characterize it as adding fuel to the fire, so to speak. There's so much happening at a national level, and the good senator from Aurora also identified within my own district, there were certainly instances of immigration enforcement whose tactics didn't align with my value system. I'm not sure they rose to the level of violation of constitutional rights, but it did feel, again, that
They should give them
we
a
are taking
time limit.
steps towards
Yeah,
truly
like a shorter time limit, because like,
from my perspective, truly trying to protect constitutional rights.
this has been going on too long.
I recognize that the bill was amended in Judiciary Committee, but as introduced,
I mean, yes, it is a delicate matter, and it is
during civil immigration enforcement by another person,
important
whether or
to
not under
a
the
lot of people, but
law, violates
if
the
they
United
would
States
have already
constitutional
voted
law,
on this,
participating in civil immigration
it would have been much more
may bring a
efficient.
civil action against the other person. Boy, the wheels were just spinning in my head about who those individuals are that were, whether or not under the color of law, and not as a practicing attorney with not even a simple country lawyer, I'm not actually sure what it means to be acting under the color of law. Like, I got to dig a little deeper to get an appreciation for that terminology. But again, as introduced, it certainly created an atmosphere that it felt like, man, this is my neighbor, anybody that had some connection to an enforcement officer, provided them information potentially that then violated somebody's constitutional rights, that they end up being held liable. That seems pretty challenging from my perspective. But to the sponsor's credit, they did reference and talk about amending the bill, and that language now reads in the pre-amended bill, a person who has their rights that are guaranteed by the United States Constitution violated by another person who now says acting under the color of any federal, state, or local law is participating in civil immigration enforcement may bring a civil action against the other person. Person found to have violated the United States Constitution while participating in civil immigration enforcement is liable to the person whose rights are violated for legal or equitable relief or any other appropriate relief. So I'm also struggling to think about the consequences, not fear-mongering. This is truly trying to understand unintended consequences of policies that we construct. But a person found to have violated the United States Constitution while participating in civil immigration enforcement. I'm not sure how far the description goes for participating in. I think about employers potentially and inquiries from immigration. And I don't know the law in that space either. I don't know what they are required potentially to divulge or not, or what privacy pieces exist for folks that are here undocumented. So I don't even know how to talk in that space, but it makes the wheels start turning and thinking about those unintended consequences of employers or acquaintances. It just gets really convoluted for me to try to work through what I believe are liable to be unintended consequences of the policy. We offered an amendment earlier today with some description about, it was really Amendment L005, and it added a clarifier that said relief, except that the person is not liable to the person who had their rights violated if the person who had their rights violated provoked the conduct that caused the violation. So again, the wheels start spinning a little bit and engage with the sponsors to some degree, maybe new terminology for me from a legal perspective, what constitutes provoked? But it did spark an interest, and I'm not sure that that definition exists anywhere right now, but it did spark some conversation and thought for me about our constitutional rights, and we'll talk just about the First Amendment in particular. They're not 100% absolute. There's the cliche always, you can't run into a crowded theater and yell fire. You don't have that constitutional right. So in this instance, thinking about this, trying to strike the right balance. Where does my constitutional right end, and where does somebody else's constitutional rights begin, and how they interact and
actually, don't you have the constitutional right to do that? To run into theater and yell fire, because that's freedom of speech. You're not supposed to do that. You should never do that. But like,
truly want to
you have the right.
Protect people's constitutional
yeah.
rights. Does this set a framework and a groundwork going forward that becomes more problematic, and again, maybe incentivizes more and more interaction, not always well-intentioned interaction, to draw people into circumstances that end up getting people in circumstances they struggle to deal with. I wish we could I think I know there are a number of immigration policy conversations unfolding in front of us this session. I thought we had reasonable conversation early with a resolution, and again, a recognition that at times our immigration system is.
They should do it like at that lower level where people have like 1 minute to talk or like 2 minutes to talk, and like
thoughtful, engaged,
boom, you're done. Go.
Conversations about the recognition of some of the dysfunctionality and how we might move the ball.
But unfortunately, politics and red tape do not go hand in hand.
With that,
it takes forever to get something done that could be done within a few minutes.
Senatorial 5, it's a very simple amendment, and we're nearly ready. Okay. I would request a senatorial 5.
We will go into a senatorial 5.
What's a senatorial 5? Is that like a 5-minute break, or are they like, what's going on here? Anyway, I have to start getting ready to go, so I'll check whenever you get back. Whenever I get back, if you're still on, I'll join in or
Yeah.
whatever. But I'll talk to you later.
Talk to you later. Well, if they're on break, there's a sponsor I forgot to put out there. If you want funny shirts, go to Threads.
All right, Senator Zamora Wilson.
And we're back.
Thank you, Mr. Chair. So as I had mentioned about my concern in this bill is the cost and the unknown. We see that that the state expenditures are around $125,000, but I believe there's going to be more, and so I have an amendment.
There is an amendment at the desk. Will the clerk please read L010?
Amendment L010, amend printed bill
Senator
page 5.
Zamora Wilson.
Thank you, Mr. Chair. I move L010 to Senate Bill 26005.
To the amendment.
Thank you, Mr. Chair. So, as I mentioned, there's going to be costs. We look over in the fiscal note under risk management that they're looking at expenditures will increase by about $3.3 million per year beginning in fiscal year 2026 to 27. And as my colleague from Brighton mentioned, possibility of 60% coming from the general fund. However, that's depending on the department. We could have the Department of Safety where all of it could be coming from the general fund. And so this amendment, what it does is the Department of Personnel will include the amount of money spent. They will highlight if the money spent from the risk management fund in this bill was, if it includes the amount spent, so if enacted, including the amount spent to defend the actions brought pursuant in this to that in beginning in November 2026 and in November every year thereafter in the budget request for the upcoming state fiscal year submitted to the Joint Budget Committee pursuant to section 23208. Basically what I'm doing is also highlighting in the SMART Acts that if there's any money, it's red flagging, it's highlighting the money that has been spent. What this is bringing about is transparency. I think it's a very reasonable ask. We need to know truly if this goes over, what the intended costs are, and it just highlights it. And there is no fiscal note. And so I ask for an aye vote on L010.
Further discussion on the amendment? Senator Kirkmeyer.
Thank you, Mr. Chair. Members, this is a pretty simple amendment, and it's for a first-time legislator who wants to ensure transparency and have an understanding of how we get information from the executive branch. There's a departmental difference in the fiscal note that instead of 125,000, Department of Personnel Administration, who manages the risk management fund, is saying that it could be more like 3.3 million or more. And all she's asking for, and there should not be a fiscal note here, because she's just saying to the Department of Personnel, in your budget request to the Joint Budget Committee, that you just need to tell us how much was spent from the risk management fund to the Joint Budget Committee. And then the next step is, and just report that at the SMART Act hearing. Now they would have to do this. If we ask for it, we could ask them for it to bring it up, but now it's in law, or she wants it to be in law, so that it's clear every year we will have a very clear, transparent understanding of how much money is being spent out of the risk management fund, whether it's general fund money, because depending on the department, this could be all general fund money. I know in the fiscal note it says general fund, cash funds, and federal funds, but depending on which department it is, it can end up being all general fund monies. So that's all this is asking. Transparency, simple report. There should be no fiscal note, and ask for an aye vote on L010.
Senator Gonzalez.
Ask for a no vote.
Is there any further discussion? Seeing none, the motion before us is the adoption of Amendment L010. All those in favor say aye. Those opposed, no. The noes have it, and that amendment is lost. Seeing no further discussion, the motion before us is the adoption of Senate Bill 5 as amended. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and Senate Bill 5 is adopted. Majority Leader Rodriguez.
Thank you, Mr. Chair. I move the Senate proceed out of order to take up Senate Bill 18.
The motion is to proceed out of order to take up Senate Bill 18. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and that motion passes. Will the clerk please read the title of the Senate Bill 18?
Senate Bill 18 by Senator Wallace and Colker and Representative Froelich and Garcia, concerning legal protections for the dignity of a minor and in connection therewith suppressing a court record associated with changing a minor's name and requiring the court to consider as a relevant factor when determining parenting time and allocation of decision-making responsibility whether the minor's parent recognizes the child's identity as it relates to a protected class.
Senator Wallace.
Thank you, Mr. Chair. I move Senate Bill 2618 and the Judiciary Committee report.
To the Judiciary Committee report.
All right, in the Judiciary Committee, we had several amendments. They ensured that youth name changes, record suppressions in Section 1 is clearly just prospective, so we're not talking about any previous name changes. We also allowed access to these documents upon presentation of an affidavit and to remove the requirement that minors have to publish their change of names, which would undo the purpose of the bill. And then finally, we struck all of Section 2, which would have included children's protected classes and best interest considerations for family court. That is no longer in the bill.
Thank you. Further discussion on the committee report. Seeing none, the question is the adoption of the Judiciary Committee report. All those in favor, please say aye. Aye. Any opposed, say no. All right, the ayes have it. The committee report is adopted. Senator Wallace.
Thank you, Mr. Chair. Despite all of that work, we have just one technical amendment.
There is an amendment coming to the desk. Mr. Schaffler, please read L6 to SB 18.
Amendment L6, amend the Judiciary Committee report
Senator
dated.
Wallace.
Thank you. Yeah, I move Amendment L006.
To the amendment, to L6.
This amendment is a technical update for statute reference.
All right. Is there any further discussion on L6 to SB 18? Seeing none, the question is the adoption of L6. All those in favor, please say aye. Aye. Any opposed, say no. The ayes have it. L6 is passed. Back to the bill. Senator Wallace.
Thank you, Mr. Chair. In its amended form, this bill will suppress legal name changes for minors, which are currently public record. Suppressed records can only be accessed by the applicable party, the courts, and law enforcement. This provision will not apply to records and will not be, and minors' name changes will not be suppressed if they are under adjudication. And as with any other legal proceeding, minors still need their parents' permission in order to change their names, and will not be able to do so without their parents' awareness. In fact, name changes like these are filed in the name of the minor's adult parents. Further, minors change their names for many reasons. These include religious and cultural naming ceremonies, family changes like adoption, and gender transition. This legislation brings documents for these name changes in line with other similar government documents. Currently, these court records are public, which means minors who have legal name changes can be identified through record searches and AI data scraping, and the public accessibility of these
I have
documents.
good news.
puts youth
Apparently,
at risk.
Flying
This
Hawaiian
bill
will
is
be
about
joining
protecting
us
minors who
soon.
change their names in an array of circumstances, and I ask for an aye vote.
Thank you. Senator Corker.
Thanks, Mr. Chair. Just to add on to that, in other parts of our court system, we have, for example, dependency and neglect cases, juvenile adjudications, foster youth and transition, and any criminal case where a child is a victim or a witness. All those are suppressed. The child's name is suppressed. So we're adding this in name changes where it's being done in other places, and I ask and I vote.
Is there further discussion on Senate Bill 18? Senator Kirkmeyer. Looks like there's an amendment
Whatever. Sure.
coming up to the desk. Senator Kirkmeyer.
Thank you. Thank you, Mr. Chair. Thank you, Mr. Chair, and appreciate the comments made by the good senators from Boulder and Centennial, Boulder County and Centennial. Where is she from? Longmont, sorry. Good senator from Longmont and from Centennial. I do have an amendment at the desk, and we can just get right to it.
Okay, Mr. Schaffler, please read L7 to SB 18.
Amendment L7, amend the Judiciary
Senator
Committee.
Kirkmeyer
Thank you, Mr. Chair. I move L007.
to the amendment.
Thank you, Mr. Chair. Appreciate again all of the amendments that were made in the Judiciary Committee. It is a big deal, given where this bill started, where again in this bill it had information with regard to allocation of parental responsibilities. This was in the original bill. Granted, it is no longer in the bill now, which included parenting time and decision-making responsibilities. All this amendment does is just confirm what the good senator from Longmont just said, that parents, not a parent, but parents would have to consent to the minor child changing their name. So it couldn't just be one parent, it would have to be both parents. And I'm just making sure. So this line would be added in the judiciary report. In the part where it says, beginning on July 1st, 2026, if a petitioner under 18 years of age at the time of filing the petition and with the consent of the petitioner's parents or legal guardians. So it would take both. So again, given where I think we all know about House Bill 1312 from last year, given where that was, and given where we are at with the original introduction of this bill with regard to allocation of parental responsibilities and also determination of parenting time, I would just ask the sponsors to consider this, because the amendment would ensure that the court cannot suppress a child's name change petition unless both parents consent. It reinforces the principle that major decisions affecting a child's identity should not be made unilaterally or without full parental participation. By preventing suppression absent mutual consent, the amendment promotes procedural fairness. Both parents retain the right, and I think it's important that we have both parents retain the right to be informed and heard in proceedings that materially affect their child's legal identity. That is all this asking. And I heard the good senator from Longmont say that it was parents, and so I'm anticipating that was the senator's thoughts in the first place, that it was to be parents and not just one parent. And all this does is just affirm that it would, and safeguard, ensure that it is with the consent of the petitioner's parents or their legal guardians, both. So we don't end up with a parent whose parenting time, or they face adverse custody or parenting time consequences. So I would ask for an aye vote on 7L007. Thank you.
Members, the question is L7. Senator Wallace.
Thank you, Mr. Chair. I appreciate the good senator's efforts here. This is already in law that parents have to be consulted if as children make these choices. If parents don't have decision-making per family court, then they already still have a right to be heard on these issues before anything progresses. So if they don't have custody or decision-making of their children already, they already have a right to be heard in court for this. So this would be, undoing mechanisms that are already in place and through family court procedure.
Is there further discussion on L7? Seeing none, the question is the adoption of L7. All those in favor, please say aye. All those opposed, please say no. The noes have it. L7 fails. Further discussion on Senate Bill 18. Seeing none, the question is the adoption of Senate Bill 18. All those in favor, please say aye. Any opposed, say no. Ayes have it. Senate Bill 18 is adopted. Madam Assistant Majority Leader or Majority Leader, Senatorial 5. All right, we're back. Mr. Majority Leader.
Thank you, Mr. President. I move the Senate proceed out of order to take up Senate Bill 31.
Members, the motion is to proceed to consider Senate Bill 31. All those in favor, please say aye. Any opposed, say no. The ayes have it, and we will proceed to consider Senate Bill 31. Mr. Schaffler, please read the title of Senate Bill 31.
Senate Bill 31 by Senators Lindstedt and Rich and Representatives Camacho and Soper concerning the lawful use of a prescription drug product containing a Schedule I controlled substance.
Thank you. Senator Rich.
Thank you, Mr. Chair. I move Senate Bill 31.
And there is a committee report as well, Senator.
Oh, and the Health Committee report, sorry.
Very good. To the committee report.
Thank you, Mr. Chair. In the Health Committee, we made one amendment. It was L001, and it would tweak the language to clear that any Schedule I drug approved by the FDA and DEA would be available in Colorado will be dispensed in Colorado in the same ways as any other prescription drug.
Very good. Further discussion on the HHS committee report. Seeing none on the question is the adoption of the committee report. All those in favor, please say aye.
Aye.
Any opposed, say no. A couple of ayes have it. The committee.
Amendment L2, amend printed bill, page 3, before line
Senator
9,
Lindstedt.
insert.
Senator Lindstedt.
Thank you, Mr. Chair. I move L2.
To the amendment.
This is a clarifying amendment that makes sure that natural medicine is not included. It wasn't included in the bill, but we wanted to put some clarifying language so that folks are comfortable. As for an aye vote.
All right. Is there further discussion on L2? Seeing none, the question is the adoption of L2 to Senate Bill 31. All those in favor, please say aye.
Aye.
Any opposed, say no. The ayes have it. L2 is adopted. To the bill. Senator Rich.
Thank you, Mr. Chair. This bill reduces red tape by removing the need for Colorado to conduct its own separate rescheduling process after the federal government has already acted. Maintaining a parallel system requires significant time and resources. And over time, this bill is also likely to save taxpayer dollars by avoiding unnecessary regulatory proceedings and potential legal disputes over conflicting federal and state classifications.
Thank you. Senator Lindstedt.
Thank you, Mr. Chair. I think Colorado patients deserve access to what this bill will do is ensure that that care is accessible and efficient. So I ask for an aye vote. It's definitely the right.
Thank you. Any further discussion? Seeing none on the question, the adoption of Senate Bill 31. All those in favor, please say aye.
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 Any opposed, say no. The ayes have it. 31 is adopted. Mr. Majority Leader.
Morning.
Thank you, Mr. Chair. I move the balance of the calendar lay over until Tuesday, February 24th.
Members, the motion is to lay over the balance of the calendar until tomorrow. All those in favor, please say aye.
Aye.
Any opposed, say no. Ayes have it. The balance of the calendar will lay over. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
You've heard the motion to rise and report. All those in favor, please say aye. Any opposed, say no.
No.
Nonetheless, the ayes have it. We will rise and report.
Nothing on our bill anyway.
Did they start on time or were they late?
Senate will come to order. Mr. Schaffler, please excuse Senator Danielson. Taking it to 205.
Mad. Mad.
So anything before you leave, you're going to be mad.
Yes.
Yeah, I literally did a whole other podcast on the House stream instead of the Senate stream, and I checked back on it and they were on 005 that entire time, and that was over an hour. And then I came back to this. It was at 1 o'clock not too long ago that they actually switched.
Oh, wow. Jeez, they need to get their butts in gear.
Yeah. At least they went through 2 bills in the last 5 minutes.
Well, that's pretty good. Maybe. What was the last bill they just did? I wasn't paying attention. What was the last bill that they just talked about?
31.
Okay,
The
go.
advocacy of minors or whatever.
I'm having a little technical difficulties. Okay. If the schedule is correct, they're doing the next one is SB 26053, and it's the concerning the expansion of eligible borrowers for mortgages through the Colorado Housing and Finance Authority. Then it's Senate Bill 26043. There's one we've been keeping an eye out on.
Yeah.
If they stick with that game plan. Oh, and you want to hear something funny?
What?
HB 261144, that's prohibit three-dimensional printing firearms and components, is on its second reading today. I think it happened. Yeah, they're trying to ban 3D printing here in Colorado for firearms. That's interesting. All right, get back from recess. What was Senate Bill 5 that was taking so long?
The rights of the immigration act.
Concerning state court remedies for violations of federal constitutional rights occurring during immigration enforcement. That was supposed to be after Senate Bill 2684. Was there anything interesting during that?
A lot of people were up in arms against it.
Yeah, because in technicality, the constitutional rights of the United States follows for citizens, naturalized or obtain citizenship through the U.S. is where it matters, where they get those constitutional rights. Illegal immigrants don't have those constitutional rights, but they do have the due process of their hearings and stuff like that. I don't understand why people have to say everyone has constitutional rights when not everyone has them. I wish the Senate would get their head out their butts and continue on. Well, if Senate Bill 43 passes today, it's going to be on a third reading with a recorded vote, then go to the second chambers.
Members, we are back in the game. Senator Weissman.
Thank you, Mr. President. The committee has been meeting and has had a couple bills under consideration. Mr. Schaffler, please read the report.
February 23rd, 2026. Mr. President, in committee of the whole begs leave to report as had under consideration the following attached bills being the second reading thereof and makes following recommendations thereon. Senate Bill 5 as amended, Senate Bill 18 as amended, Senate Bill 31 as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. Senate Bill 53, Senate Bill 43, Senate Bill 84, Senate Bill 46 laid over until February 24th, 2026, retaining their place in the calendar. Senate Bill 37 laid over until February 25th, 2026, and retaining its place in the calendar.
Senator Weiss.
Thank you, Mr. President. I move the Senate adopt the report of the Committee of the Whole.
The motion is adoption of the Committee of the Whole report. There is an amendment at the desk. Mr. Schaffler, please read S001 and Senate Bill 18.
Amendment S001. Senator Kirkmeyer, move to
Senator
amend.
Kirkmeyer.
Thank you, Mr. President. I move S001.
To the amendment.
Thank you, Mr. President. This is an amendment to the Committee of the Whole report to show that Amendment L007 did pass. L007 to Senate Bill 2618 did pass. The amendment was pretty simple. It just said that the petition, that it would take the consent of the petitioner's parents, not just a single parent or legal guardians. I understand that parents get notified whether if they do not have custodial rights of their child, but they only get heard. They don't have consent. This could happen after custodial rights have been decided and years later, and all of a sudden one of the parents may be cut out of making what are very important decisions in a child's life that may not have been mediated at the time of custody when maybe the child was younger. So again, the judicial forms are very clear. Both parents do get heard, but consent is not necessary by both parents. And what this amendment did was require that consent by the petitioner's parents, both parents, would be required. So I am asking for an aye vote on S001.
Further discussion. Senator Wallace.
Thank you, Mr. President. Members, I urge a no on this amendment. There is a family court system that is set up to handle these things. If a parent has lost custody of their children, they are still able to be heard around name changes like this, but they are not able to make the final decision. Putting this amendment in would change this from every other structure of family law and how parents' time and other things are accorded. So I would urge a no vote.
Seeing no further discussion, the motion is the adoption of S001 and Senate Bill 18. Are there any no votes? Senators, Mr. Majority Leader, Cutter, Wallace, Marchman, Gonzalez, Kip, Judah, Amabile, Henriksen, Snyder, Weissman, Ball, Colker, the Majority Leader again, Sullivan, Lindstedt, Bridges. Please add the President. With a vote of 15 ayes, 17 noes, 0 absent, 2 excused, and 1 vacant, S001 and Senate Bill 18 is lost. Again, the motion is adoption of the Committee of the Whole report. Are there any no votes? Senators, Kirkmeyer, Committee of the Whole report. Senator 5.
Well, that's good that they didn't pass that because there's, like she said, already things in place in the courts. All right, come on, get to Senate Bill 43.
Again, members, the motion is adoption Committee of the Whole report. Are there any no votes? Senators, no votes for Committee of the Whole report. Senators, Frizzell, Zamora Wilson, Kirkmeyer, Pelton B, Carson, Pelton R, Catlin, Liston, with a vote of 24 ayes, 8 noes, 0 absent, 2 excused, and 1 vacant. The Committee of the Whole report is adopted. I need something to read. Yeah, there it is. Senate Bill 5 is amended, 18 is amended, 31 is amended, passed second reading, order in gross place account for third reading and final passage. Senate Bill 53, 43, 84, 46 laid over until 2/24/2026 and retaining their place on the calendar. Senate Bill 37 laid over until 2/25/2026, retaining its place on the calendar. Consideration of governor's appointments. Consent calendar. Mr. Schaffler, please read the appointments listed on the consent calendar.
Members of the Juvenile Parole Board, effective November 16, 2025, for terms expiring November 15, 2029. Lori Comer of Denver, Colorado, to serve as a representative of the Colorado Department of Labor and Employment, appointed. Kim Branham of Thornton, Colorado, to serve as a representative of the Colorado Department of Public Safety, reappointed. Heidi Jean Hess of Clifton, Colorado, to serve as a public member of the Western Slope that is not employed by the state governor, reappointed.
Majority Leader Rodriguez.
Thank you, Mr. President. I move for the passage of all the appointments on the consideration of governor's appointment consent calendar, which are Lori Comer of Denver, Kim Branham of Thornton, and Heidi Jean Hess of Clifton for the Juvenile Parole Board.
Any discussion? Seeing none, the motion is the confirmation of the appointments on the consent calendar. Are there any no votes? With a vote of 32 ayes, 0 no, 0 absent, 2 excused, and 1 vacant, those appointments are confirmed. Message from the House.
Mr. President, the House has passed on third reading and transmitted to the Revisor of Statutes, House Bill 1070 and House Bill 1182. The House has passed on third reading and transmitted to the Revisor of Statutes, House Bill 1071, House Bill 1034, and House Bill 1136, amended as printed in House Journal February 19, 2026, and House Bill 1115, House Bill 1096, and House Bill 1142, amended as printed in House Journal February 20th, 2026. The House has passed on third reading and returns herewith Senate Bill 10. The House has passed on third reading and transmitted to the Revisor of Statutes, Senate Bill 52, amended as printed in House Journal February 20th, 2026.
Message from the Revisor.
We herewith transmit without comment House Bill 1070 and 1182 without comment as amended. House Bill 1034, 1071, 1096, 1115, 1136, and 1142 without comment as amended. Senate Bill 52.
Introduction of bills.
Senate Bill 120 by Senator Marchman and Wallace and Representatives Zokai and Bradley concerning law enforcement procedures related to missing persons.
Straight to the governor's desk. Judiciary. I'm just joking. Announcements. Senator Weissman.
Thank you, Mr. President. Judiciary Committee, we are meeting in just a little bit. Usual time, 1:30, usual place, Old Supreme Court to hear 4 bills. They are 1035, 1064, Senate Bill 70, Senate Bill 71. Members, we have closing in on 100 witnesses in total for our afternoon's docket. Please don't make any evening plans. See you soon.
What? Senator Colker.
All right, get to
Members,
Senate Bill 5.
Senate Bill, or excuse
Or
me,
not
Education
5,
Committee will be
43.
hearing at 1:30 today. We are hearing one bill, Senate Bill 67, and a number of appointments to the Institute of Cannabis Research Governing Board.
Senator Assistant Majority Leader.
Thank you, Mr. President. Senate Transportation and Energy will be meeting at 1:30 in Committee Room 352. We'll be hearing for action only Senate Bill 26021.
Senator Pelton, Radiant.
Thank you, Mr. President, but I think you need to get your eyes checked. It's
I
that
do.
time of year again.
I do.
Or time of the week again. Bible study tomorrow morning down in the basement, 7:15. Come feed your soul and we'll feed your belly too.
Very good. Mr. Majority Leader.
Thank you, Mr. President. I move the Senate adjourn until 9 a.m. Tuesday, February 24th, 2026.
You heard the motion. All those in favor say aye.
Aye.
Opposed,
Did
no.
we just go through all this
Ayes
and
have it,
still
Senate
didn't
will
read Senate
adjourn
Bill
until 9 a.m.
43?
on Tuesday, February 24th, 2026.
Sounds like it. I've been on here since 11 a.m. and it's 2 o'clock.
What the? Oh my God. I want to see something. This is ridiculous. Oh my God. All right, sorry everybody for this. We thought Senate Bill 2643 was going to be presented today. It was on their list. Even said it on the legislation website. February 23rd, 10 a.m., Senate chambers. That they didn't read out Senate Bill 3 or 43. So we're going to stay on top of it and figure out what went on, why it did not get presented.
Yeah.
And all right. This seems like this bill is more of a, sorry my language, shit show than originally expected. And you got to kind of figure it's Senator Tom Sullivan. He knows how to create a shit show out of everything. So
Guess we'll be back on tomorrow.
I will stick on top of it tonight or throughout the day because I'm waiting on it to update. It might update at midnight, may not. I don't know. But if I do see an update on it, I will update you so we can try to figure out what we're gonna do here.
Yeah.
So again, sorry everybody about this. The non-reading when it says supposed to be a reading of it. So all right. Well, mahalo for watching. Aloha. See you guys on the next one for Senate Bill 43.
Yep. See ya.